Thank you, Madam President, and thank you to all members of the independent bench in particular, and to members on the government side for a recognition of a living reality, and that is that law is a living thing, and our job as legislators is to keep the law under review and to continue to respond to societal changes. We live in an interesting time. I will admit to being something of a dinosaur in the times that we live now, in particular with reference to the reality of something known as social media, which is so relevant to the conversation that we are having today. And so it is very important that we recognize, as we continue to return to the wheel of effort and industry, that we must not be too self-critical or criticize each other too harshly, when what we really are trying to do is to keep up with the times. Only this morning I was having a conversation with a gentleman for whom I have great respect, who is much more au fait with the reality of social media than I am. And I was genuinely taken aback by some of the tales that he was, not tales, some of the accounts he was giving me of the passage of the population of young people that he would observe in the malls and elsewhere going into parties, and how they are dressed. And all of it is on video now and is being exchanged and shared on social media. This is the reality that we have to continue to address. And what we are about here today is one of those attempts to continue to keep under review, and I emphasize that, to keep under review the pace at which our society is developing, and to keep it under review so that we might continue to regulate ourselves and those whom we love, our citizens, in a manner that is responsible and responsive, so that we can continue to leave and to bequeath a rich nation to the citizens of this country. May I say thank you in particular to those senators who have made substantial contributions to the effort that we are making here. And I would just like to respond to some of the comments that have been made. And I would start with the opposition comments that have been made. There has been, of course, the return to the criticism that the term "without delay" is not sufficiently clear. And there was a suggestion by opposition Senator Lachmidial that it should be given a more, to use her term, definitive timeline. I've spoken to the meaning of "shall" without delay. I'm not going to return to that nor repeat it. I was just slightly taken aback in the context of the suggestion that "shall" without delay is so without meaning that it should be given a more specific timeline, to then find that when the senator turned to subsection 57.3 and subsection 57.3 Roman 2, which is introduced by clause 6 of the bill, there was a suggestion that the 7-day period was not a realistic period, and it should somehow or the other be relaxed to allow for a greater period of time for the verification of the information. So I don't quite follow this suggestion on the one hand, that "shall" without delay doesn't demarcate a timeline, but then when you have a timeline of 7 days, that should somehow become more elastic. I rest on the fact of what I have already submitted, that the words "shall" without delay are sufficiently clear in the drafting language and sufficiently clear for any reasonable interpretation that would have to be made by a court of law if it were to meet that case. This suggestion was also made, Madam President, that the impact that a public sex offender register will have is dependent on populating same, which requires detection and conviction. Well, that is precisely the job of the Trinidad and Tobago Police Service. That is the purpose of the sex offenders register and the sex offenders website. I have already said that with respect to the question that has been asked of me by Senator Dylan Remy, I will make inquiries and I undertake to return in due course with sufficient information to address that and to ensure that there is a synchronicity between the relevant parties who are charged with responsibilities under the legislation to ensure that both registers, that is to say, the sex offenders register and the website, are populated properly. There is a concern that I would address immediately, which was raised by independent Senator Richards, for whom I have the greatest respect, and I would address that immediately. He was suggesting, and with great justification, that there should be some greater control of the default that the police might be guilty of in complying with the responsibilities that are visited on them by this legislation. And while I accept that we want our police service to function as efficiently as they possibly can, and we will always encourage them to, I would urge caution that we can't expect, short of violations of the law and breaches of specific responsibilities, to cast penalties in the legislation on the failure of a police officer to perform a time-bound responsibility within a reasonable time. At the end of the day, it would seem to me that we have to encourage our police officers to act responsibly, having regard to the duties that are imposed on them. And if they don't, then there is recourse that will have to be availed, recourse to the Commissioner of Police, recourse to the Police Service Commission, recourse to the Police Complaints Authority for disciplinary action to be taken against the police officers who are being derelict in the discharge of their responsibilities under the legislation. But I don't think that in this legislation we could entertain putting in a penalty to be exacted against a police officer if he does not do something within 7 days. But of course, that is a matter that I will have to advise myself on with more expert advice than I am capable of rendering to myself in consultation with the draft persons within the Ministry of the Attorney General, and it is a question that I would want to look at. I don't believe that we can address that today. And of course, we know that there are other amendments that we will be coming to this House with. Voyeurism is one of those amendments. And if in due course we think that there are tightening up procedures that can be engaged in along the lines that Senator Richards has suggested, certainly we will return to deal with them. We can't deal with those today because I don't see how we can exact penalties by way of breach of statutory duties on the police officers for failing to comply with a responsibility within a reasonable time frame. One of the other suggestions, useful suggestions that came from Senator Richards, which one has to accept, there is the possibility that the website could go down, it could be hacked. Well, again, we have to rely on the fact that so far we are assured, and this website has been in existence for some time, that the police service is applying very serious skill sets and taking a very responsible approach to ensuring that the website is properly managed. And therefore, again, I don't know that we can make prescriptions in the legislation for what happens if the website is hacked. The fact of the matter is that if the website is hacked, there are other laws under which the hackers will be held responsible. So we don't need to detain ourselves in respect of this legislation to prescribe offenses, in my respectful view. The question of locality being too broad, another suggestion raised by Senator Richards, and not narrow enough so that the address of the person is unknown. Well, the Act does not specify any address within the locality, but simply the area where the person resides. And when one looks at Schedule 3 to the Act in respect of the National Sex Offender Register, you will see the detail that is spelled out there. So that I think that with the assistance of an effective police service, who will be recording the sex offenses that are registered and registrable, that the issue of the locality not being sufficiently clear ought not to impede the proper implementation of the legislation. Senator John spoke to detection and conviction, which will feed into the website. Well, those again are joint responsibilities and efforts of all of the stakeholders, in particular the investigative and detective processes of the police once an offense is reported, and then we can rely on the sex offenders register, which is in existence, which we can take the comfort from knowing that even though the website may not be populated in the way in which critically Senator Dylan Henry has pointed, Remy, I beg your pardon, Senator, Remy has pointed out on the research that she's done, we do have that sex offenders register, which is maintained in confidential terms by the police service. When one looks at Section 54 of the Act and Schedule 3, which spells out in great detail items listing beyond item 22 and continuing, the details which are known to the police, which are held confidential, and which will enable the police to pursue registered sex offenders who have committed offenses, the heinous offenses that this legislation seeks to inhibit and prohibit. So I think that we can rest assured in response to Senator John's comments that we have sufficiently functional sex offender register, and we certainly, in response to Senator Dylan Remy, will be looking to investigate the potential room for improvement of the website. Senator, my good friend, Senator Thompson, Hazel Thompson, IE, as did Senator Dylan Remy, made the point which I started with, and that is law is a living thing. When the Act was first amended in 2022, 33 members of the legislature joined together in a commendable effort to pass the amendments that were passed at the time. And we are not all perfect, and I dare say that not one of those 33 senators would today suggest to themselves that they were so imperfect that would have rendered utterly unnecessary the need to return today, as we do today, to improve the quality of the legislation, as we shall continue to do, because law is a living thing, and legislation must keep pace with the progress or the lack of progress of a society. The mental assessment point that was raised by Senator Hazel Thompson, IE, Section 61 of the Act already deals with that, where a person makes an application to be exempt from registering as a sex offender or reporting requirements. The court has a discretion to conduct a mental assessment under Section 61 of the Act. So there is that provision there, which is of assistance in respect of the concern raised by Senator Remy. We find as well that under Section 70, Senator Hazel Thompson, he spoke of a person who was found not guilty by reason of insanity or disability should be included in the register. Well, such a person would not, first of all, be considered a sex offender under the law if you suffer from an insanity or disability. But under Section 60 of the Act, the Parent Act, where a registered sex offender has a mental disorder and is required to report to a police station, he may be accompanied by a representative of his choice. So he or she, that is, so that the Act reaches out to contemplate realities which we are all grappling with and realities which we must be sensitive to as we pass legislation to regulate people's everyday life. Senator Wade Mark has, in his inimitable style, made contributions which I think every other speaker in the House has addressed, and I therefore don't think that I need to trouble this House with a response to Senator Mark. Senator Dylan Remy made the point that I have already addressed, which I am grateful for, that the time frame of 7 days and 3 days, she questions whether these are sufficient to verify the accuracy of the information. I say two things on that. We have to remember referencing back to Section 42, first of all, Section 2 of the Act, which defines a sex offender. A sex offender is defined as someone who has been convicted. And then we go to Sections 46 through to later sections of the Act, and we remind ourselves that the sex register, offender register, and the websites are registers by which we record information that comes out of recorded convictions, so that we can be satisfied, in my respectful view, unless there is something fundamentally wrong with our court system, that if the courts have convicted someone of being a sex offender and that person is then registered on the website, that there has been a sufficient verification process. And I would not suggest, given our sense of urgency to make this legislation as effective as possible in its implementation, that we need to trouble ourselves to further verify the fact of the commission, the conviction which has been recorded by a competent court of law. Senator Dylan Remy spoke of the recording of the information after verification should be done digitally. That will have to be a decision that the Trinidad and Tobago Police Service would no doubt have to look at. I dare say, as a nation, as we move towards digitization of our entire governmental and public administrative system, that we will get to the point at which it will all be digitized, a step at a time. We are doing the best that we can as we move towards a better society in which our vulnerable and our citizens can feel safe. Madam President, in the circumstances, I do not think that there is much more that I can say at this stage, and in all of the circumstances, I beg to move.
Honourable Senators, the question is that a bill entitled